it's an important point that you mentioned. I'm going to start with the last point first, which you talked about probate, and and nomination should be equal to a will. So I think it's a subject that leads to heated debate. I was very surprised when a very respected judge told me, "Why do you need wills at all?" And Joby, Mathew will tell you, and Rekha Kurola, his wife, that you must make a will. And constantly, we have been, for the last 14 years of Moneylife, we have told everybody you must make a will. So it was such a radical thought. I know that Mr. Harsh Roongta also believes, why do you need a will if you can get nomination? And there are very strong views. So I'm going to start with Mr. Roongta because he agrees with you that nomination should be made good enough. And that Mr. Mathew, who says, no, there are serious issues. I think people need to hear both sides.
No. Let me just clarify. As of today, there is no choice but to make a will. Okay, nominees are only trustees, except possibly for life insurance. We don't really know. It's not been tested.
I will interject here.
Yes, sir.
Nominees are trustees because there is a requirement of a will where it can override it.
Yes, sir.
But if you go to the earlier statement that you made, if there is no will, then nominations will work. Unless I will hear. So I am eager to hear all sides.
No, so sir, as of now, that is the position. My point was that even when we talk of a will, we have been accustomed, just like probate is a thing that harks back to 77 years back. Will, we have been accustomed to saying the will should be of all assets together. What is nomination? If you are a properly declared asset by asset successor, if I can have a will asset by asset, right? That I think, yeah, and if that is allowed legally. I mean, if that has to have the force of law. Currently, it does not, right? So let us recognize that. So today, when we talk to clients, we'll make sure that they have their will. I have written my will. I mean, that is without question. What we are talking about is what we should advocate. My point is, people have this strange aversion to writing wills, because I mean, you get all kinds of excuses for people not to write wills. People don't have that aversion when they do asset-wise nomination. So I'm saying, if we can convert that mental acceptance of doing asset-wise nomination through some legal changes, if we can convert that into a will, it will be asset-wise, right? While at the same time somebody wants to make a full-scale will, let that supersede a asset-wise will, but allow a asset-wise will. That was the only point.
Yeah, it's on. So yes, I mean, let me address this one point that Mr. Roongta said about the hesitancy to write a will. We actually got one of our friends who was a psychologist to sort of try and understand why people are having this problem. One, of course, is the morbidity. I mean, you don't want to face the fact of your own death or the possibility of your own death. But there's a very interesting statement that I read somewhere, that a will is also a way in which you control your assets after your death. So, you try to become immortal. You immortalize yourself. So that's a very interesting thought, I thought, because at the end of the day, you prescribe that, look, this piece of land should go to this son, that jewelry should go to this daughter, the saris will remain with my wife. So at the end of the day, after death, you're still trying to control what is happening to your assets. Whereas, karma, whatever philosophy is that all of this is, you're freed of all of this after death. But there's also another point, and that's really the history of wills. I was learning about wills in college. So wills really originated in the UK and in the English law, and wills were really a way to get property out of the hands of the church, because they had these ecclesiastical judicial systems where the church would take anything because it belonged to God and therefore it belonged to the king. They would take out anything in which there was no will. So people used to write wills to ensure that their property was saved from this. But we, of course, don't have that, thankfully, at the end of the day. But that probably is also one of the reasons why an Englishman would write a will and we would then hesitate to write a will. The English have a very evolved system of doing that. They have a central will registry. In fact, that's one of the things that we found, where your wills are recorded, wills are registered, and if you pass away without, a legal heir, then there's a very organized system of how the state gets the property, etc. But to come back to what Mr. Roongta said and Mr. Kamath also had suggested, can nomination replace the will? Yes, in financial assets, yes. But in terms of other assets, like for instance real estate, where the movement of title or the transfer of title is a lot more complex than something that you simply write, there one may have to be a little more careful about how assets transmit due to the death or after death, because verification, disputes, these are factors that then contribute to how the transmission process can be more complex or not. Record keeping is another aspect, because in a financial asset, whether it's a bank deposit, whether it's insurance policy, or whether it's a security asset like a share or a bond or whatever, record keeping is very well done. But on the other hand, now you have, for instance, gold ornaments. Now you buy them, you don't always keep their receipts. So record keeping in respect of those may not be pakka. So there a will contributes to a large extent in ensuring that proper distribution of assets. Some of these challenges are there, but therefore unless there's a comprehensive way of, let me put it this way, validating the transfer instrument or the asset being transferred, it's still too early for nominations to replace wills completely.
What about what Mr. Roongta says, that are there legal changes that you can put in place to give a little more weight and sanctity to nominations?
Nominations, see, at the end of the now Supreme Court has interpreted or declared that a nominee is a trustee. But at the end of the day, now the trustee can also be the legal heir. So, at the end of the day, it all depends on who gets the title, really. So, if a bank deposit is to go to the son or to the daughter or to the daughter-in-law or to the grandchild, now by making the nomination, you're really telling the world that, look, this is the person to whom I would like this asset to pass after my death. That's exactly what you do in a will. So in that respect, there's nothing wrong, nothing different. But the question is, again, that's the question about probate, and therefore the presidency town argument. British era thing, there were 3 presidency towns, chartered high courts, they were given the powers to probate the will. Probating the will is nothing but getting the seal of approval of the court and saying that, look, this will is properly done, you've got the force of law. Nothing more than that. But the process takes a long time, and people try to take shortcuts by getting a succession certificate or a legal heirship certificate or things like that, putting a advertisement in a newspaper. It doesn't really substitute it. But nevertheless, if the law were to be amended, now the Uniform Civil Code, with all the controversies that it has, I think there's an excellent opportunity for doing this, because it sort of tries to ensure that all issues relating to personal law, whether it be marriage, whether it be succession, are addressed in one single code. And that's a good opportunity, because if that can then provide that, look, you give a nomination that amounts to a certification of the succession part, that will be a brilliant idea.
So I have one more point on nominations before we close this part of it, which is that if you make nominations stronger, then the person who's making the nominations has to do it very, very thoughtfully and with an awareness that his own life may change. So a person is married today, he may get divorced, he may have, he may get remarried. So you have to be, people are very careless about finances, they have to be very up to date. There's also a challenge about how people think. So we've been doing seminars now for 14 years, we've been discussing wills, and we have all kinds of cases come up. So most of you know that by and large, it is women who outlive men, right? But there are many men who think that their wives are incapable of handling finances. And so the nominations are either the children without providing for the wife, and we have had bizarre cases where even a business partner has been made a nominee because they think that they can trust him and he is going to look after the family, and it has not happened, right? So if you then do not go by succession laws, which are a form of protection, because under the succession law you can challenge and you say the nominee gets it, there's such a danger when the person who's nominating has been careless or thoughtless. I mean, is this something that either of you would want to comment on, or you must comment?
I think the challenges remain the same whether it is nomination or wills. You have to do it carefully. And if circumstances change, you need to change it.
If it's intestate, it goes by succession.
True,
Yes.
true. It goes by succession. So if, as long as, like we tell in our planning practice, as long as you make your choices consciously, you can take a conscious choice that I do not want to choose. I let it go by succession, and it will cause issues to my, because for getting that intestate succession, there is a certain process they will have to go by. Versus, like it is happening in movable assets, okay, effectively possession being 9/10 of law, because of nomination, the asset goes to the intended nominee. Yes, he or she is holding it as a trustee, but I mean, they can do with it what they want. Yes, they are accountable to the legal heirs, but I mean, for the legal heirs to get the nominee to be accountable, they have to go to the courts, and we know what courts are. So, for all intents and purposes, effectively, nomination has become equal to succession in movable assets. The only problem is in immovable assets, which is where I am saying, ki make that, nomination is happening today in immovable assets, especially if it is a cooperative society, a flat in a cooperative society. But there the Societies Act provides that you cannot transfer it, the nominee cannot transfer it, cannot create third party rights, etc. In fact, so much jugaad is happening. Societies are not aware of this law. Buyers of flats are not available. The nominees are not, they don't know. You have chains of such flats being sold. God alone knows when the issue will come up. Even in other places, I mean, lots of places, just based on a registered will, flats are, I mean, properties, immovable properties are getting transferred based on a registered will. Nothing else, no other court process. Some other process, but no other court process. So, my point is, jugaad is already, we are a land of jugads. So, jugaad is already going around this. Will nobody writes? I mean, let us recognize that. I mean, let me ask here, how many people in the room have written a will? That's good. I mean, this is still, yeah, and that's still only 35%, right? Okay. And if I had asked this question 5 years ago, probably my own hand wouldn't have gone up. Although I wrote my will 20 years ago. So my point is, nobody writes a will for whatever reason. And therefore we need to sort of do something to ensure that this huge problem of assets does not get bigger. That's my limited point.
Harsh, if I may just, if I look back the process, I think there are two parts to it. One is writing a will, you are putting down your assets, and secondly, you are nominating who will get what. Now, if you look back in time, both these processes had to be done by writing it down, because there were no records available of it. This is part of the problem for the first part of it, the IEPF shares and all, because there is no record. In today's world, at least as you rightly said, the financial part of it, all the financial assets, I think we are now one step away from putting it in one place. Today, mutual fund central accumulates, gets you all your bank accounts. We can search under a single. We can get that. It's only insurance now, which is not mutual funds, of course. So it's only insurance which has to be brought in now, and then the financial side of it is taken care of, except for any cash that you may have, so and gold that you may have. So I think these may have to be addressed. But then comes the things like property. There again, if you look at it, the evolution over the last 10-15 years, because land records were not digitized, so there was no other way that you could approach it. So who is the arbiter? And now, once it is digitized, if we try to apply the same mindset that was there earlier, that's where I think we will create more problems. Now you mentioned the problem of societies. This is an unbelievable problem. Nobody understands the society's the laws under which this is operating and what is happening. So finally they say that you get a probate. And even after a probate, the process is not very clear. So there is a whole lot of self-education that is required by people who are administering. And given that technology has evolved to a place, to a certain, to a level where it is today, and the common man is able to access things, I think we need to slowly push this envelope for the good of ourselves, the common person, that this can be made as easy as possible finally. We started, the first slide that was put up was very important. That is unclaimed dividends. In today's world, or unclaimed shares. In today's world, this has no place. Everything should be searchable and claimable. So start from there and then you get down to land records. I think there is a solution available, but I entirely accept it's not today. So you will need a transitionary path. And you may still need a will for a different purpose.